Leading Case 17. P. Ramachandra Rao v. State of Karnataka 3 SCR 64 SCC 578. In this video, we delve into the landmark case of P. Ramachandra Rao v. State of Karnataka 3 SCR 64 SCC 578, a significant judgment that has shaped the legal landscape of India. This SCC report is a crucial legal precedent that has far-reaching implications on criminal law, constitutional law, and civil rights. Our legal analysis of this case study provides an in-depth examination of the judicial review and legal principles that govern the court's decision. We explore how the Indian Supreme Court's interpretation of the law has influenced legal history and continues to impact court decisions to this day. Gain valuable insights into this important case and enhance your understanding of legal principles and judicial review. Hi, I am Advocate Dr. Saurabh Kapoor, bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly like, subscribe and hit the bell icon to my YouTube channel to view videos like this more. Please leave a comment below telling your thought and idea about this video and future videos you want. Kindly share this video with your friends, family and social groups to spread this knowledge. Chief Justice S.P. Bharucha, Justice Syed Shah Mohammed Quadri, Justice R.C. Lahoti, Justice N. Santosh Hegde, Justice Doraiswamy Raju, Justice Ruma Pal and Justice Arijit Pasiat. Introduction. The case deals with the issue of whether the Supreme Court, in its zeal to protect the right to speedy trial of an accused, can prescribe time limits or bars of limitation beyond which a criminal trial or proceedings cannot continue, even though the legislature and statutes have not chosen to do so. The case arose from appeals against the acquittal of accused persons facing corruption charges by special courts, as there was a failure to commence the trial despite the lapse of 2 years from the framing of charges. The High Court allowed the appeals by the state without issuing notice to the respective accused. 2. Background. The judgment traces the development of the right to speedy trial as an integral part of the fundamental right to life and liberty under Article 21 of the Constitution, through various landmark cases such as Hussain Ara Khatun and Maneka Gandhi. In A.R. and Tully's case, a Constitution bench declined to prescribe time limits for the conclusion of criminal proceedings, holding that it is neither advisable nor feasible to do so. However, subsequent cases like Common Cause and Rajdeo Sharma prescribed such time limits, leading to the present reference before a larger bench. 3. Causes of delay in criminal trials. The judgment discusses various factors contributing to the delay in criminal trials, such as poor judge population ratio, inadequate appointment of public prosecutors, non-service of summons/warrants, non-production of under-trial prisoners, and adjournments sought by counsel. It emphasizes the need for collective action by the legislature, judiciary, executive, and bar to achieve the goal of speedy justice. 4. Judicial legislation and binding precedents. The majority opinion, authored by Justice Lahoti, holds that prescribing time limits tantamounts to impermissible legislation by the judiciary, which is beyond its power. It also violates the doctrine of binding precedents, as the decisions in Common Cause and Rajdeo Sharma run counter to the Constitution bench decision in A.R. and Tully's case. Courts can declare the law, they can interpret the law, they can remove obvious lacunae and fill the gaps, but they cannot entrench upon in the field of legislation properly meant for the legislature. The majority opinion reaffirms the dictum in A.R. and Tully's case and holds that the guidelines laid down therein adequately take care of the right to speedy trial. It states that the criminal court should exercise their available powers under the Code of Criminal Procedure to effectuate this right. V. Dissenting opinion. Justice Raju, in his partly dissenting opinion, agrees with the conclusion but expresses reservations about the observations regarding the powers and jurisdiction of the Supreme Court. He emphasizes that the Supreme Court, as the ultimate repository of judicial power, should not disown its jurisdiction when the Constitution and fundamental rights are at stake. Vi. Conclusion. The appeals are allowed, and the High Court is directed to hear and decide the appeals afresh after noticing the accused respondents, consistently with the principles laid down in the judgment. The Court clarifies that the decision shall not be grounds for reopening cases where acquittal or discharge has already achieved finality based on the overruled decisions. The judgment reminds the union and state governments of their constitutional obligation to strengthen the judiciary by providing requisite funds, manpower, and infrastructure. Right to speedy trial, an inalienable right under Article 21 of the Indian Constitution. Introduction. Administration of justice is not limited to the conviction of the guilty person and acquittal of the innocent one, but it also deals with the fair and speedy trial. We all know the fact that the speedy trial is the need of the hour. Speedy trial is one of the basic human rights, as without speedy trial justice cannot be said to be done. It has been endorsed in almost all international charters and conventions. Most notably, one of them was ratified by India on 10 April 1979, which was civil and political rights. The directive principles of state policy articulated in Articles 38, 39 and 39A of the Constitution of India, and also on account of India's international legal obligations to guarantee delivery of justice on time. No existing law specifically provides for any time frame for the conclusion of the trial, and if any time frame has been provided in any statute, then it is directory, not mandatory. The Supreme Court through its various judgments observed that speedy trial is inherent under Article 21 of the Constitution. Article 21 of the Indian Constitution provides that no person shall be deprived of his life and personal liberty except according to the procedure established by law. The protection under Article 21 is available not only from executive actions but also from legislative actions. In Munn v. Illinois, the court held that the term life meant something more than mere animal existence. Justice Bhagwati in the Maneka Gandhi case observed that the expression personal liberty in Article 21 is of the widest amplitude, and it covers a variety of rights which go to constitute the personal liberty of man, and some of them have raised to the status of distinct fundamental rights and given additional protection under Article 19. The terms life and liberty are very comprehensive terms, and if interpreted includes a person's right to a speedy trial. Life and liberty are for the living. Every person has a right to live a free and healthy life. In the case of the victim, he ends up visiting the court for years to get justice. In the case of the accused, he languishes behind bars for years awaiting trial. We all know that an accused is not guilty until proven guilty. In both cases, parties to a proceeding. Such delay in proceedings violates their right to life and personal liberty and leads to mental anguish. Their worry, anxiety, expense and disturbance due to undue delay should be minimized. Article 21 of the Constitution guarantees that no person shall be deprived of his life and personal liberty except according to the procedure established by law. The Supreme Court, in 1978, in the Maneka Gandhi case held that for the deprivation of life and liberty of a person, two conditions are necessary. There should be a law, and the law should be reasonable, fair and just. The procedure prescribed by law for depriving a person of his liberty cannot be reasonable, fair or just unless that procedure ensures a speedy trial. Speedy trial under Article 21 in India, criminal cases go on for years, even sometimes for decades, and if we take a look at civil cases, the condition is horrible. Speedy trial is important to safeguard the miscarriage of justice as well as undue and oppressive incarceration, and ensures dispensation of justice by providing fair and just trial to all its citizens. After independence for 2 decades, courts were not very much concerned with the length of time an undertrial prisoner spent in prison, but what they maintained was that the prosecution had to justify the continued detention of the undertrial. But the post-emergency Supreme Court recognized the importance of not letting the incarcerated languish behind bars and evolved a series of fundamental rights that were not expressly present in the Indian Constitution. This included the fundamental right of speedy trial under Article 21 of the Constitution. In 1979, Hussain R. Khatun v. Home Secretary, State of Bihar, a petition was filed for a writ of habeas corpus on behalf of a large number of men and women, including children, who were languishing behind bars for years awaiting trial, and that the offenses, even if proved, would not warrant punishment for more than a few months. The apex court, in this case, held that the right to a speedy trial is a fundamental right implicit in the right of life and personal liberty provided under Article 21 of the Indian Constitution. In its decision, the court mandated greater access to bail, more humane living standards, and a significant reduction in time from arrest to trial. The court observed that no procedure which does not ensure reasonable quick trial can be regarded as reasonable, fair and just as interpreted in Maneka Gandhi case. Hence ordered the Bihar government to release forthwith the under-trial prisoners on their bond. Delay in process. The main purpose of a speedy trial in the criminal justice system is to ensure justice to the victim and protect the accused from unnecessary incarceration before his conviction. So, the demand for speedy trial arose due to unnecessary delay in the disposal of cases. In 1981, State of Maharashtra v. Shampel Punjabi observed that while deciding the question of whether there has been a denial of the right to a speedy trial, the court is entitled to take into consideration whether the delay was unintentional, caused by overcrowding of the court's docket or understaffing of the prosecutors, and whether the accused contributed a fair part to the time taken. There are many reasons which can be responsible for the delay in the trial. The most popular among them are: on the part of the judicial system, like pendency of cases, the vacation of court, judge population ratio, independence of the judiciary. On the part of the counsel, like taking adjournments, lengthy arguments to impress clients, no preparation of the case. on the part of the accused, like absconding, non-cooperative behavior, etc. Consequences of delay. The real question before the court was how to identify whether the delay is proper or not, and if it is proper, then what would be the consequences of such delay. To understand the answer to this question, let's have a look at some landmark judgments of the Supreme Court. Sheila Barsa v. Union of India, 1986. In this case, the Supreme Court held that if an accused is not tried speedily and his case remains pending before the magistrate or the Sessions Court for an unreasonable length of time, it is clear that his fundamental right to speedy trial would be violated unless there is some interim order passed by the Superior Court or deliberate delay on the part of the accused. The consequence of such a delay would be that the prosecution would be liable to be quashed. Abdul Rahman Anchali v. R.S. Nayak, 1992. In this case, the Supreme Court, in this case, held that the right to a speedy trial under Article 21 is available at all stages, namely, the stage of investigation, inquiry, trial, appeal, revision and retrial. The court laid down detailed guidelines for the speedy trial of an accused in a criminal trial but refused to set a time limit for the conclusion of the trial. The court held that the nature of the offense and the circumstances may be such that quashing of proceedings may not be in the interest of justice. In such a case, it may make an order that the trial may be concluded within a fixed time and reduce the sentence. P. Ramachandra Rao v. State of Karnataka. In this case, the apex court laid down certain factors to identify whether an accused has been deprived of his right to speedy trial. They are: 1. Length of delay. 2. The justification for the delay. 3. The accused assertion of his right to speedy trial, and 4. Prejudice caused to the accused by such delay. If nothing is shown and there are no circumstances to raise a presumption that the accused had been prejudiced, there will be no justification to quash the conviction on the ground of delayed trial only. Durga Datta Sharma v. State. In this case, FIR in question was filed in the year 1980 and the charge sheet was submitted in the year 1985 and the case was committed in 1991, and in this way, since the date of filing the FIR, 14 years have been elapsed for which the court held that the petitioner has been deprived for the constitutional right of getting a speedy trial. The prosecution under the Prevention of Corruption Act has not commenced after 25 years. No charges have been framed and chances of commencing and concluding the trial soon were not strong. Observing that the accused persons had already suffered a lot both mentally and physically during the last 25 years, the court dropped all charges against the accused. Rajiv Gupta v. State of Himachal Pradesh. In this case, the apex court held that if the trial of a case for an offense which is punishable with imprisonment up to 3 years has been pending for more than 3 years and if the trial is not commenced, then the criminal court is required to discharge and acquit the accused. From the above judgments, we can infer that if a person is facing trial for a long period awaiting justice, it would impede speedy trial, and the same would be violative of Article 21 of the Constitution. To ensure speedy trial, the apex through its various judgments from time to time not only emphasized the need for a speedy trial but also laid down detailed guidelines to counter the delay in proceedings. There is a catena of pronouncements by the Supreme Court and the High Court wherein the courts held quashing of proceedings, dropping of the charges, the acquittal of the accused and right to bail of the accused as some of the remedies to the consequence of the delay of the proceedings. Provisions under CRPC. Besides the above judgments, there are various legislative provisions under the Code of Criminal Procedure, 1973 to ensure speedy trial, already existing provisions. Section 157 of CRPC imposes a duty upon the police officer, who on receiving information of commission of an offense, has to immediately send a report of the same to the magistrate and to proceed to the spot to investigate. Section 173 of CR.P.C. provides a mandatory provision to complete all the investigations given under the Chapter 12 of the CRPC without unnecessary delay. Section 207 of CRPC. The accused has a right to get free of cost copies of O police report, O FIR recorded under Section 154, O statement recorded under Section 161 of all persons, O confession in the statement recorded under Section 164, O any other document forwarded to the magistrate with the police report under Section 173, Chapter 21 of CRPC. From Section 260 to Section 265 provides for summary trial in certain petty offenses. Section 468 of CRPC provides that after a certain period, there is a bar to take cognizance of offenses specified in subsection. It means the limitation period is 6 months for the offenses punishable with a fine only, 1 year for the offenses punishable with imprisonment for a term not exceeding 1 year and 3 years for the offenses punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. Provisions inserted through amendments. Section 167 of CR.P.C. deals with the most important concepts of criminal procedure that are police custody, which is granted at the initial stage of investigation for only 15 days. Judicial custody is the detention of the accused after 15-day police custody and default bail. In case of offenses punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years, the investigation is not completed within 90 days, and in case of other offenses, the investigation is not completed within 60 days, then on expiration of such periods as the case may be, the accused shall be released on the bail. It indicates the intent of the legislators to safeguard the accused from unlawful long detention and harassment. Section 173 of CR.P.C. provides that the investigation of the offense of rape shall be completed within 2 months. The period of 2 months starts from the date on which the information was recorded by the officer in charge of the police station. Chapter XI of CR.P.C. provides provisions for plea bargaining. This chapter applies to offenses for which punishment is less than 7 years. It does not apply to offenses that affect the socioeconomic condition of the country or offenses committed against a woman or a child below the age of 14 years. The objective behind bringing the concept of plea bargaining was to give fair resolution to a criminal charge at a faster rate than would be possible with a full trial. Section 309 of CR.P.C. was inserted to prevent delay in the trial, and it provides that the proceedings to be conducted on day-to-day basis until the examination of all the witnesses have been done. It also provides that the trial relates to an offense under Section 376, 376A, 376B, 376C, 376D, 376DA, or 376DB of the Indian Penal Code, 1860. The inquiry or trial shall, as far as possible, be completed within 2 months from the date of filing of the charge sheet. 2 provisions were added which deals with certain circumstances in which no adjournments shall be granted. Remedies available in case of delay in proceedings. The right to a speedy trial is a fundamental right inherent under Article 21 of the Constitution, which provides for the right to life and personal liberties. Our Constitution provides that whenever there is a violation of fundamental rights, a person can move to the Supreme Court under Article 32 and to the High Court under Article 226 of the Constitution. In P. Ramachandra Rao v. State of Karnataka, the court laid down certain guidelines and held that the powers conferred under Sections 309, 311 and 258 of the Code of Criminal Procedure shall be exercised by the criminal courts to effectuate the right to speedy trial. To seek appropriate relief and directions, the jurisdiction of the High Court under Section 482 of CR.P.C. and Articles 226 and 227 of the Constitution can be invoked. So, if we see from the top to the bottom of the article, we can see that from time to time the right to a speedy trial was emphasized as being a fundamental right under Article 21 to reconcile justice and fairness with many other interests which are compelling and paramount. The Supreme Court has emphasized the above propositions again and again in its judgments. In Kartar Singh v. State of Punjab, the Supreme Court held that the concept of speedy trial is an essential part of Article 21 of our Constitution. This right to speedy trial begins with the arrest of the accused and consequent incarceration and continues at all the stages of investigation, inquiry, trial, appeal and revision so that prejudice caused by the impermissible and avoidable delay can be averted. Conclusion: from the above facts, we can conclude that initially, the speedy trial was not so important, but after the period of emergency, the courts started taking interest in providing speedy trials to prevent unnecessary harassments to the parties to a criminal proceeding. The apex courts through its judicial pronouncements held that speedy trial is an inalienable right under Article 21 of the Constitution, and hence no person shall be deprived of his life and liberty without the procedure of law, and the procedure of law must be fair, reasonable, and just. The right to a speedy trial is available at all stages, namely, investigation, inquiry, trial, appeal, revision and retrial. The Supreme Court in its various judgments emphasized that a person can approach the Supreme Court under Article 32 and the High Court under Article 226 to enforce the right to a speedy trial. However, the court at various times refused to fix a time limit under which a trial has to be concluded. At last, after making so many provisions to ensure speedy justice, the people of India are still not getting speedy justice in the true sense. There exist various reasons for the delay in the trial. Though the right to a speedy trial is a fundamental right, it still requires empirical study and comprehensive law for its meaningful application. Did you know that this landmark case set a powerful precedent in Indian law, emphasizing the importance of police accountability and the rights of citizens during arrests? Welcome back to Leading Cases, where we dive into the most influential judgments that have shaped the Indian legal landscape. Today, we're discussing P. Ramachandra Rao v. State of Karnataka, a 2002 case that has far-reaching implications for the relationship between law enforcement and citizens. This case is significant because it highlights the importance of upholding human rights, even in the face of crime and punishment. As we explore the facts and ruling of this case, you'll see how it has had a lasting impact on police procedures and the rights of accused individuals. The Supreme Court's decision in P. Ramachandra Rao v. State of Karnataka has been cited in numerous subsequent cases, making it a crucial part of Indian legal history. So, let's dive in and explore the background of this pivotal case. P. Ramachandra Rao was arrested on July 15, 1997, by the Bangalore City Police on suspicion of being involved in a criminal conspiracy. During his arrest, Rao alleged that he was subjected to third-degree methods of interrogation, including physical and mental torture. He claimed that the police had fabricated evidence against him and that his arrest was unlawful. Rao's counsel argued that the arrest was in violation of Article 22 of the Indian Constitution, which guarantees protection against arrest and detention. They contended that the police had failed to follow proper procedures during the arrest and interrogation, resulting in a violation of Rao's fundamental rights. The state of Karnataka, on the other hand, argued that Rao's allegations were baseless and that the police had followed standard procedures during the arrest and interrogation. They claimed that Rao was trying to escape accountability for his alleged crimes by making false allegations against the police. The trial court ultimately dismissed Rao's petition, holding that the police had acted within their powers during the arrest and interrogation. Rao then appealed to the High Court of Karnataka, which also dismissed his petition. Undeterred, Rao approached the Supreme Court, which agreed to hear his appeal. During the appeal, Rao's counsel argued that the police had failed to comply with the mandatory requirements of Section 50 of the Code of Criminal Procedure, which deals with the rights of arrested persons. They pointed out that the police had not informed Rao of his right to silence or his right to consult a lawyer before making any statements. The Supreme Court, in a landmark judgment, held that the police had indeed violated Rao's fundamental rights by failing to comply with the mandatory requirements of Section 50. The court observed that the right to silence and the right to counsel are essential safeguards against coercion and false confessions. The court also emphasized the importance of police accountability, holding that the police must be held accountable for any violations of human rights during arrests and interrogations. In a significant observation, the court stated that the police cannot be allowed to act as if they are above the law. The Supreme Court's ruling in P. Ramachandra Rao v. State of Karnataka has had far-reaching implications for police procedures in India. The judgment has led to a greater emphasis on police accountability and a recognition of the importance of upholding human rights during arrests and interrogations. The ruling has also led to changes in the way police officers are trained, with a greater focus on human rights and the rights of accused persons. In addition, the judgment has prompted a rethink on the role of the police in society, with a greater emphasis on community policing and building trust between the police and the public. However, the ruling has not been without its critics. Some have argued that the judgment has made it too difficult for the police to carry out their duties effectively, particularly in cases involving serious crimes. Others have pointed out that the emphasis on human rights has led to a culture of police impunity, where officers are less likely to take risks for fear of being held accountable for human rights violations. Despite these criticisms, the significance of P. Ramachandra Rao v. State of Karnataka cannot be overstated. The judgment has been cited in numerous subsequent cases, including those involving allegations of police brutality and human rights violations. As we reflect on this landmark case, it's clear that the Supreme Court's ruling has had a lasting impact on the Indian legal landscape. The emphasis on police accountability and human rights has led to a more nuanced understanding of the relationship between the police and citizens. The case also highlights the importance of an independent judiciary in upholding the rule of law and protecting human rights. In a country where the rule of law is paramount, judgments like P. Ramachandra Rao v. State of Karnataka serve as a beacon of hope for those who seek justice and accountability. So, what do you think about this landmark case? Do you think the Supreme Court's ruling has had a positive impact on police accountability and human rights in India? Let us know in the comments section below. If you have any suggestions for future cases you'd like us to cover, please let us know. We'd love to hear from you and explore more fascinating cases that have shaped the Indian legal landscape. Thanks for watching, and we'll see you in the next video.